Most of the times we tend to get questions relating to the probate of a will. Hence, in our today's discussion, we are going to deal with how to probate a will, its procedure, and the duration for probating a will. Let's first start with a brief introduction. The Indian Succession Act 1925 under Section 2H defines a will. It is defined in this section as a legal declaration of a person's intention with respect to his property to take effect after his death. A will is a legal document. Property is disposed of through a will. Any person, whether a relative, friend, or colleague, or their blood relations, can be named in a will. Generally, a will becomes effective after the death of its maker, who is called as the testator or the testatrix. However, in some cases, the property can also be transferred during the testator's lifetime. A will's validity is proved by the testator's signature and the attesting witnesses. But if the will is probated, it becomes more credible. Now, let's look at how long does the probate process take. A probate certificate is the official proof of the will. With the court seal, the executor is authorized to execute and implement the will. Probate gives will a legal status. Probate of a will facilitates the distribution of a deceased person's estate to his heirs and beneficiaries. As a part of the will, creditors are also paid off their debts. It is possible to apply for a probate 7 days after the death of the testator. Probate of wills typically takes 6 to 9 months to complete. Depending on the seriousness of any objections, it may even take 2 years for the probate of will process to be completed if there are any objections to the will. Now let's look at how does probate of a will work. Probate is the act of proving or validating something. Essentially, it involves the court approving the will of the deceased as valid and long-lasting. Probate of will establishes the will from the death of the testator and deems all intermediate acts by the executor valid. The Indian Succession Act of 1925 specifies that probate establishes the will from the death of the testator. In other words, when a will is probated, it becomes officially authorized with the seal of the court, and the executor is given authority to distribute the assets of the deceased testator to pay off his or her debts. Again, a basic question that comes into the mind of all of us is, does a will require probate? The probate of a will is not mandatory, as there are various circumstances which make it unnecessary in certain cases. Although state laws may vary, the surviving owners inherit assets automatically when they own them in joint names with their children, spouses, or other individuals, and there is no need to probate or create a will to transfer the assets. In some cases, a probate would be required if there were a problem with the existing will. It may also be that the testator predeceases the beneficiaries. In other words, if no beneficiaries are named in the will, or when the estate belongs solely to the deceased testator, then a probate is required. Then the question is, what is the process? There are 4 simple steps involved in probating a will. Probate petitions must be duly signed and verified by or on behalf of the applicant before they can be submitted to the district judge. Probate petitions should follow a prescribed format under Code of Civil Procedure 1908, and they must be filed within 7 days of death of the testator. In the second step, the application is sent to the High Court, which has jurisdiction over the property, and an attorney will then prepare the application which may also be accepted by a lower court in some cases. In order to verify the validity of a will, death certificate and other required documents have to be submitted. These are evidences of free will on the part of the testator. All details are verified by the court when it receives the application. Afterward, it invites the deceased's closest kin to claim probate. Lastly, it displays the invitation letter prominently in case any objections are raised. Probate is issued if there were no objections from any quarters after 30 days of the court order. How does probating a will work? When a deceased person leaves last will and testament, probate is the process of authenticating it under the supervision of a court. A decedent's estate is administered by locating and valuing his asset, paying his final bills and taxes, and distributing his remaining property to his heirs. Probate is required for whom? When you become executor, you must apply for probate in the country where the decedent lived at the time of his or her death. Additionally, you need to file the death certificate and the original will. What is the purpose of a probate? When the assets of an estate are solely owned by the deceased, probate is necessary. It is necessary to probate an estate before property can be transferred to a beneficiary. When someone dies, do you have to apply for a probate? Probate is not required for every individual, but if you are named in someone's will as an executor, you may need to apply for it. A will gives you the authority to share out an estate according to the instructions in the will. How does probate work? Assets belonging to the decedent are considered probate assets. The decedent may have titled property solely in his or her name or held it jointly with other tenants. It is also possible to include personal property such as jewelry, furniture, or automobiles. Hope the information is useful. Thank you very much for your patient hearing.